Beautiful people, welcome back. Evidence is the backbone of everything you do, whether it is you're in a formal court or not. If you are in any circumstance where you're trying to come in as any capacity, evidence is the backbone. Merely narrating a fact is not the same as having the evidence. Most people, when they deal with things, when they try to fend off claims, when they try to assert a claim against someone or regarding what they are, they fail to understand that what they ought not to do is to not mimic what a canine does behind a closed gate. And usually when that gate is open, that canine just looks away and walk away like nothing ever happened. That's what usually occurs with most people. They do a lot of talking, they send in a lot of paper without any actual result. It makes and match a lot of things that sounds logical and reasonable and moral, but the operation of law does not support it, because that thing they're mix and matching actually contradicts their intent. And the process of that, a lot of people also use buzzwords. A lot of people throw words around like standing, capacity, claim, and many more, without even understanding or comprehending that in order for you to have a standing or capacity, there has to be an element or elements specific to that type of right that you're invoking. If you don't know the elements specific to the right that's being invoked, you're not doing anything. If you don't know the test that qualify the element and that specific circumstance that gave rise to that right of action, you're not doing anything. If you don't comprehend the standard of evidence, you're not doing anything. And what does all that give birth to? It gives birth to a tortfeasor on the other hand that's more comfortable. There's a video in the past that was shown regarding sovereign citizens and how they just categorize everyone, regardless of whether what you're saying makes sense or not. They just put a blanket term on it as a sovereign citizen. You know the reason why they can do that? Because they're comfortable that most people don't know what they're doing. They're comfortable that most people cannot hold them liable for it. So here we have a lot of people stuck on the stage of they're fraud, they're bad. And then you realize that's the limits of their capability. The limits of most people's capability is to simply say they're fraud, they're bad. Most people fail to comprehend that presumptions is the reason why they're suffering. Presumption that you are a party to that birth certificate, which makes you a joinder, which provides you as a party to that severe liability in their commercial activity. Severe liability being a specific term of its own about how to join people, join their parties. Most of these people who say they're a fraud and that they're bad know these things loosely. Yet, they out of their own mouth say, don't go into their courts to do this and that. Don't remove the presumption. Instead, send some paperwork in saying you're doing special appearance. Saying that you're of this capacity and standing a man in the land, a sovereign, a secure party. And unfortunately, some Moors have been following that also, which truly breaks my heart, because it ought not to be that way. In the process of freeing yourself, you ought not to get deeper into that thing that you intend to free yourself from. If one is suffering from a presumption and you're doing it your best to not entertain that presumption, then that presumption stands. especially where there are preponderance of evidence that you are a surety to it. If you don't speak to it to the contrary, it stands and remains, regardless of how you feel, what you say, or what you know. The mere accumulation of information serves you no purpose or significance if you cannot apply it or do anything with it. That is what the majority of people in today's world, they say they intend to be free, that is what they suffer from. The very small aspect of how that expresses itself, or why that expresses itself, is a lack of people's comprehension of what evidence is. The majority of the people, their limits of comprehension of how to enforce anything is put an affidavit of fact, affidavit of truth, do one thing or the other, put some paperwork in, and say you're doing a special appearance, and that's it. None of that is considered evidence. Evidence is the backbone that keeps everything standing. If body of a law is synonymous to the physical body, evidence would be the bone that holds the muscles, the tendons, the fat, or the organs upright. Without the bone, everything is just flapping all over the place loosely. The majority of the people that intend to free themselves do not comprehend the principles of evidence, because intrinsically they've abandoned how to automatically. They're saying it's their rules though, so don't study it. These people talk about common law, but fail to realize that the common law that they run about so much, they speak of common law affidavit, proper common law this. They don't even know the origin of common law. They don't know that the common law that they're dealing with has its origin in England. The people that their forefathers ran away from. And if your forefathers did not run away from the British Moors at England, at Great Britain, and you're still harking and going on about common law, and you fail to realize that common law is in fact a modern homogenized version of English law. Common law and English law are the same thing. If one does not comprehend that, and you think common law is separate from that thing that you're trying to run away from, that is another form of delusion that makes the other party very, very comfortable. Merely accumulating a lot of information and knowing a lot of buzzwords is not synonymous to solution. Evidence. There are types of evidence. There's prima facie evidence and substantial evidence. Prima facie evidence is merely narrating the fact that they don't have jurisdiction, or saying that you're whatever capacity you think you are. Meaning it's just on its face. Does that make it admissible? No. Substantial evidence is based on the corroboration of what compels performance, whether through its value, which the terminology and legalese is called merit. Most people's paperwork are meritless. It has no laws behind it, behind how those people feel. Hence, it's inadmissible. Substantial law is admissible evidence. I always speak of the rules of evidence in the state and federal level. And we're not even going into books that speaks in details about the different arts, yes, arts, that exist in common law, let alone equity or other types of law. We're just going over the most basic stuff that's easily available. We're not going over manuals, handbooks that are not publicly available. And if they are, they're worth tens of thousands of dollars. We're not even going over that yet. We will be. But if we don't go over these basic things, none of that will make sense. An observer will listen to it and think they know what's being spoken of. But if they haven't graduated as basic principles first, it's just another sound, feel-good conversation for them. That just sounds good. Get off the hype train of merely getting involved in a conversation or accumulating an information just to go back to your regular life to suffer from the symptoms of lack of knowledge. That stuff is not impressive. And that stuff perpetuates serfdom, slavery, that you purport to want to get away from. You want your words written on that piece of paper to hold ground? Then learn about how evidence works, because it is a backbone to everything you say you are, that you say that they don't have the capacity to do, and that you're claiming that you have the ability to do, or that you saying that they are, which is you're saying they're a fraud. Most people say they're fraud and don't even know that there are different types of fraud. Most people say that they, quote, are fraud and don't even know the standard behind how to prove different types of fraud. Ask some of these people out here, secured party creditors, man in the land, patriots, or even some Moors. Ask them, what are the different types of fraud and how do you prove them? And tell them to just clarify it to you under 30 seconds. Tell them, those people speaking about trust, ask them the different types of tests to be able to pierce that trust and how it relates to corporate veil. They won't be able to tell you. Most people speaking about their fraud, they're a corporation as legal as a corporation. Ask them about the test and standard behind the corporate veil and what a close corporation is. They will not be able to tell you. Yet, these are the people fueling the hype train that thousands of people are behind. And guess what? Those on the other hand want just that. Incompetence, it's what fuels them. What fuels most people who say that these other people are fraud, it's just the need to speak up. If you just have a need to speak up and you're not directing it properly with proper knowledge, and most importantly, functionable knowledge, it's equivalent to a waste of time. And deep down, most of those people know that what they're going on about remains insignificant. And when you really look at their track records, they are usually ones that please, take sentencing fines, forfeit their estates. Yet, you see them talking a whole lot of stuff on all these social media pages. No understanding or comprehension of how law functions. The basic stuff. Be very careful and understand these foundational basics first. Admissible evidence. Admissible evidence is evidence that may be presented before the trier of fact, for example, judge or jury, for them to consider in deciding the case. And admissible evidence, a judge or a jury, is not always limited to a formality of what people see as that court building. It goes on to say, rule of evidence determine the type of evidence is admissible. Meaning you want all these things you're saying on a piece of paper to exist according to the operation of law. And the trial court judges apply these rules to those cases. And the battle of legalese is not synonymous to boxing or any other form of martial arts where you're on one side and you're on the other side and the referee's telling you, okay, be fair, do this, do that, all right, let's go. No. They just come at you and that's it. If you don't know what to do, you're screwed. Generally, to be admissible, generally, meaning general laws. Generally, to be admissible, the evidence must be relevant. We spoke about the different 19 types of objections, and it speaks, one of them is regarding relevance. And the type of objections that you deal with is directly intertwined with the different types of evidence and the standards of evidence. Where also you see a lot of people speak of, oh, you gotta object. You gotta tell them to sustain or overrule it. They cannot and will not sustain or overrule your objections if you don't specify the type of objection that you are evoking. The evidence must be relevant and not outweighed by countervailing consideration. In contract, there's consideration and performance. You want to compel performance, right? What is the consideration? For instance, the evidence is unfairly prejudicial. How do you prove prejudice? You're saying they're fraud. Well, how do you prove it? Confusion, which is what most people do. Or a waste of time, which is what most people do. Privileged, or amongst other reasons based on hearsay, which is what most people do. So let's go to the rule of evidence. We're going to determine what makes an evidence admissible. In the past, we've spoken about the different types of documents, the ones that are authenticating, self-authenticating. We've spoken about the different types of objection. We've spoken about affirmative defense. We've spoken about accord and satisfaction. Many more things in doctrines. You merely having what you say is an evidence does not necessarily make it admissible. You merely going on a piece of paper does not make it an evidence, let alone before determining whether it's relevant, admissible, or not. Rule 402, the uniform version, which is Federal Rules of Evidence. You will always, as always, you will always find this on your corresponding slate level. Rule 402, general admissibility of relevant evidence, meaning the things that will be considered as evidence. If these are not part of the situation, you're just living in your own little reality. Relevant evidence is admissible unless, meaning what they're about to list are the only thing that could create exception to what is about to be spoken of here. Relevant evidence is admissible unless any of the following provides otherwise: the United States Constitution, a federal statute. Since the United States Constitution is mentioned first, then that means this federal statute must be in harmony with the Constitution. These rules, or other rules prescribed by the Supreme Court, meaning common law, judge-made law, that many people go on and on and on about. Irrelevant evidence is not admissible. They place it right there for you. So if one comprehends what is considered a relevant evidence, automatically you know that the opposite of that is irrelevant. And as we go through this, you will see the majority of what people do, despite it being moralistically correct and relevant, despite it being emotionally correct and relevant, despite it being a norm within the normal standard of operation of daily life. When it comes to law and its operation, which is legal aspect, the doctrines, the standards, the elements, the tests, so on and so forth, all those things that are moralistically, emotionally, and normally relevant are considered irrelevant evidence, because all laws are specific. In this case, the law of evidence, and the rules which serves as the operation of those laws. 403, excluding relevant evidence for prejudice, confusion, waste of time, or other reasons. The court may exclude relevant evidence if its probative value. In the past, I've spoken about probative value, evidence with probative value. You always hear me say that. The court may exclude relevant evidence if its probative value is substantially. Remember, we spoke about substantial evidence and prima facie evidence. So these words are very specific, and they're incorporated into the explanation of what is relevant or not. So pay close attention. The court may exclude relevant evidence if its probative value is substantially outweighed by a danger of one or more of the following: unfair prejudice, confusing the issue, misleading the jury, undue delay, wasting time, or needlessly presentive, cumulative evidence, meaning you're talking too much and repeating the same thing in different forms, which is what most people do. In the past, we went over Rule 410 regarding how you can withdraw your pleas, so we're not going to go over that again. 404, character evidence, crime or other act. If you comprehend Rule 404 and 405, you realize that your criminal record can never be used against you. all that 3 strikes rule, all that stuff about them saying, well, he's done this before, so he's a danger to society. Or you've committed a crime of violence, so you're convicted felon, so your right to bear arms, we're going to take it. You can't bear arms. And of course, most people signed conditions for probation, aka supervisory release. So that's contract law on one hand. On the other hand, they got another loophole for you, which you can be put into use. Being put in jeopardy of the same crime, the double jeopardy clause within the Constitution. This is it right here in Rule 404, the Fifth Amendment. The Fifth Amendment. No person shall be held to answer. No person shall be subject for the same offense to be twice put in jeopardy of life or limb. This clause right here that speaks about, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. It is very easy to interpret as, if one commits the same exact crime, then that's the limits of applicability of this clause. That's not true. There are many case laws to the contrary. There are many case laws that let you know that if someone is pointing to a previous act that you did in the past, which is also in a harmonious with Rule 404 or 405, which we'll go over, and it's supported by case law and stare decisis, common law, judge-made law, that says the double jeopardy clause is not just referring to, well, this guy engaged in theft in the same place regarding the same item twice, and because of that, well, we'll let him go now because of the double jeopardy clause. No. The double jeopardy clause is saying if someone did something in the past and now you're pointing at it in order to increase the severity of another current act, that is categorized as double jeopardy. Because this current act would not have its effect had you not pointed at a previous one. Now you're doubling down on them, right? That's double jeopardy. When someone is pointing to your previous act, what they're doing is they're pointing to your character. And because of that, they're saying that you are a danger to society. And because of that, some substantive right has to be stripped away from you in order to prevent you from doing that. That's double jeopardy. And the harmonious part of quote unquote their rules, which is not their rules, regarding double jeopardy is Rule 404. Remember now, we're speaking to the merits of what is admissible as evidence. Meaning now you have to be multifaceted. You have to look at it from the point of how you can put it to use. And most importantly, how they cannot put it to use. You're saying they can't do one thing or that, right? Well, know the dynamics of it. Beyond merely harking and barking that they cannot do one thing or that. So let's get into it. Character evidence. Prohibited use. Meaning it's a commandment that prohibits something. Like when they say you're a prohibited person, you can't bear a firearm. Or when they put a temporary restraining order on you, aka an injunction. At law, the verbiage is temporary restraining order or restraining order. At equity, the verbiage of the same intent and the same effect of the intent is called injunction. Same tool, different terminologies, and different outreach. Prohibited use, meaning this itself is an injunction. Just as much as the Constitution has on its face injunctive relief right off the bat, which is self-executed. Wherever it says no person shall, it commands no person shall do this, no person shall do that. That's an injunction right there. But moving on. Prohibited use, evidence of a person's character. aka your criminal records, crimes, or other act. Evidence of a person's character or character trait is not admissible to prove that on a particular occasion the person acted in accordance with the character or trait. This is so succinct and so clear that even someone who is not used to reading legalese comprehend exactly what this means. Evidence of a person's character or character trait, aka your criminal record, is not admissible to prove that on a particular occasion the person acted in accordance with the character or trait. So you're saying that that legalese is not your name and that record is not yours. But guess what? There's a presumption that it is you, and they act accordingly because that is the only medium they can communicate with you. So at some point in the past, people are saying, well, they can't do this, they can't do that, stay out of there. But now they're slowly saying, well, use a trust. And use a trust to interface with them. Okay, so people are slowly getting it. Good. But now, how do you use that trust and what are the dynamics of it? This is it right here. Again, evidence of a person. They're not delineating a natural person or artificial person, but they are saying a person. And the presumption of that person is you, whether or not you like it or agree with it or not. If you don't agree with it, then speak up and bring these basic things up. Speak up and show how you are not that legalese, rather than saying that, oh, I'm not going to show up, but I'll put some paperwork in. All right. They'll issue a warrant and you will end up submitting one way or the other, because your lack of entertaining and shutting that thing down shows that you are incompetent. And more importantly, it shows that you're afraid, whether you like to accept it or not. That's right. And the thing about a bully is a bully gets more comfortable when it sees that the one being bullied is afraid, and that the one being bullied does not have sufficient wisdom or knowledge or capacity to enforce what ought to be, which is the act of not being bullied. Evidence of a person's character, meaning they've done a severe liability, a joinder between that presumption and you, until you, the one that you say you're living flesh and blood, stands up and say, no, that's not me, and you can't do that. And you're merely putting things on a piece of paper, and you're saying you're the living man, yet you're sending fictitious. Do you not know that those words in that paper is fictional? And the only thing that brings it to life is you, the one saying that you're flesh and blood on a piece of paper. So you're saying you're not going to show up, yet you're sending a piece of paper in. So you remain in the realm of fiction. And in the realm of fiction, you're telling them that they're fictional, yet you're doing the same thing. So that means you've co-signed it, and it's all right for them to do whatever they want. One has to see these things for what they truly are. A lot of people study these things just to perpetuate what they already feel like it's supposed to be. So they only listen to things, look at things, read things, and seek things out in a manner that only just makes them feel comfortable in that small stage that they are in. Deep down, they do not want to evolve. Deep down, they do not want to take self-responsibility. Deep down, they are afraid. And it's all right. Fear is normal. They just want to do everything else on the side, but actually entertain the main issue. Again, what then is the difference between that and a canine barking behind a gate? And when the gate is open, what can you do? Nothing. Make sure that all that barking that's been done is significant, whereby when that gate opens, you go. Exceptions for a defendant or victim in a criminal case. They're saying, okay, you can either be a victim or a defendant. You don't want to accept liability? Cool. Well, come in as a victim. They're telling you. The following exceptions apply in criminal case. Meaning, even though we cannot do double jeopardy on you by pointing at your previous act, Here's a loophole for us. But we know that you think this is our rule. So we'll put things in an effective manner to take advantage of you because you're not going to read it anyway. So good. Exception for a defendant or a victim in a criminal case. The following exceptions apply in a criminal case. A defendant may offer evidence of the defendant's pertinent trait. Look at this. A defendant may offer evidence of the defendant's pertinent trait. These pertinent traits, it's a delineation of what you're saying that you're not, that is legis is. Do you know how to prove that? Beyond just narration of your affidavit of fact, affidavit of truth. That affidavit has no standing where there are loopholes of affirmative defense. That affidavit has no standing where there are loopholes whereby it is naturally presumed that you don't even have a standing to put those things in that piece of paper in the first place. A defendant may offer evidence of the defendant's pertinent trait. Who's who? And if the evidence is admitted, keep in mind they can do this to you too. And if the evidence is admitted, the prosecutor may offer evidence to rebut it. Subject to the limitation of Rule 412, a defendant may offer evidence of an alleged victim's pertinent trait. And of course, we know the victim or the people who they bring into the case as an alleged debtor is that in legis, right? Meaning you can bring the pertinent trait of what it is to clarify how a severe liability, an adjoinder of your real body, your natural person, cannot be joined with that artificial one. And if the evidence is admitted, the prosecutor may, in due process, the prosecutor may offer evidence to rebut it and offer evidence in the defendant's same trait that no, you are the ens legis. Why? Because look at this and look at that. Or look at your previous history. This is you. Right? This is what they're going to say. I'm not saying it's right or wrong on their end. But this is what they do. And this is how they make a living. And in a homicide case, the prosecutor may offer evidence of the alleged victim's trait of peacefulness to rebut evidence that the victim was the first aggressor, meaning now a physical and actual man or woman was harmed. Now you have to show that, well, you were defending yourself, like the castle law, the stand your ground law, etc., all that. Exceptions for a victim. And it seems that a lot of people who also study these things tend to forget that capacities differ. The capacity spoken of is that of a plaintiff or a defendant right here. Yes, the plaintiff can be a victim also, depending on what are you doing, a cross claim, a counter claim, whatever it is you're doing. So a lot of people will look at this and categorize a defendant or victim as the same. No. These are just code words, legalese. It's letting you know this applies to either the defendant or the plaintiff. Think multifaceted. Read beyond what's on the black and white and understand what the meaning of the words are. So now they've explained to you about the defendant and the plaintiff. Now they're telling you about a witness. In the previous video, there was some gung-ho observer with a short attention span that really doesn't understand the difference between a witness, a claimant, and a defendant. Don't fall victim to the simplicity of words. Pay attention to details. And this said observer doesn't even have the ability to fix basic stuff like a misdemeanor issue in his life. That's tragedy. That is the definition of tragedy right there. Most people suffer because they don't know the basics of how things work. Most speak of capacity and standing, but they don't even know what it is. nonetheless, exception for a witness. Evidence, meaning we're not speaking about the tortfeasor, which is the defendant, or the victim or the one stating a claim upon which relief can be granted, which is the claimant, creditor, or plaintiff. This is just someone who has some type of information that might be pertinent to support a claim by either the defendant or the plaintiff, or the presumption that exists before the right of action even arose in the first place, which might be, oh, you're the ens legis, or, oh, you're not the ens legis. A witness, and the exception to the witness. Evidence of a witness's character may be admitted under Rules 607, 608, and 609. Then in order for this man or woman to come in and start to add things on the record, what is your character like? That is in 607, 608, and 609. We'll deal with that in another day. Crimes, wrong or other act. The supposed criminal record. Prohibited use, meaning an injunction. Evidence of a crime, wrong, or other act is not admissible to prove a person's character in order to show that on a particular occasion the person acted in accordance with the character. Evidence, meaning they actually have an evidence against you. And what qualifies that evidence against you as to whether it's admissible or not, meaning, oh, look, this guy that we're prosecuting shot someone 2 years ago, robbed a store 2 years ago, slapped somebody in the face 2 years ago, trespassed against his property 2 years ago, failed to identify 2 years ago, stole a vehicle 2 years ago, did not pay child support to arrears 2 years ago. Look, we have the paperwork. Look at it. It's a crime. He did wrong. Or whatever else that they're saying, you did this once upon a time ago. And because of those things that we're bringing now on this piece of paper, that we're saying, yep, we got you. Because we're going to use it to prove who you are, in order to show that on a particular occasion, which is this recent instant, this recent occasion that took place, that you acted in accordance with the character. Whenever they bring you a previous, whatever it is, mugshot, some type of past history of whatever it is, what they're doing is a character analysis on you, that you've done this in the past, so you're well known to do this. And because of that, whatever it is that we're dealing with now, whether it's related or not, we're using that as evidence against you. That makes you a liability to society and public at large. So we now have the right to prosecute you. We're now doing our duty as a prosecutor to help the society stay safe, aka public safety. They will do this to you. And their so-called their rules is telling you they cannot do that. And it is in harmony with the principles of double jeopardy. Permitted uses, notice in criminal cases, aka exceptions to the injunction, the prohibition. This evidence may be admissible, meaning this is how your criminal history or any claim of a previous act by you in the past can now be used against you. This is a loophole to it. This evidence, remember, even these rules, they modify it. For instance, this one was updated last in 2011. They modify it based on common law, the Supreme Court laws. Remember, they tell you everything in here is what it is, unless the United States Constitution or Supreme Court decision, meaning the appeal court that makes the final determination of what common law is. And once that is done, they modify it accordingly. So, however it's worded here, it's in harmony with case law also. That is one of the reasons why they constantly change it over and over as the court decisions are made. This evidence may not be admissible for another purpose. What evidence? Your character, act, wrongdoing, of crimes, whatever it is, may be admissible for another purpose. What is that another purpose? Such as providing motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of action. Meaning all this, you deliberately used previous things and opportunities from that thing that they are now bringing in. You used it to accomplish this new thing. Meaning they have to prove by preponderance of evidence that that previous thing that they are bringing in was used with knowledge. You planned to corroborate that previous thing. You prepared to corroborate that previous thing. And you intended to use that previous thing. And you utilized the opportunity that that previous thing afforded you as a motive to do this recent thing that's causing them now to bring that old thing up. So whenever they bring your previous criminal history or the supposition of your criminal history in the past, whenever they bring it up, how is it related to the newer thing? Did you use it as an opportunity? Did you intend to use that previous thing as an opportunity? Did that previous thing serve as a preparation or a plan? Or afforded you the knowledge and you were doing it intelligently and not coincidentally to corroborate the new thing with the old thing? If they cannot prove that, then your supposed criminal history is dead and is not admissible as evidence. According to Rule 403 and 404 and 402 of Federal Rules of Evidence, which will be synonymous in the state level also. On a request by a defendant in a criminal case, then you now have to speak up. If all you're saying is you don't have jurisdiction, you have to prove subject matter jurisdiction. Jurisdiction can be proven at any point. Yes, all that is true, but how do you do that? This is part of how you challenge jurisdiction. This is it right here. If you don't know the dynamics, you're just making yourself comfortable in the preliminary stages and the introductory part of the main thing. All those things people talk about, jurisdiction, and it can be challenged, all that is just introduction. It's like a street sign that's pointing you somewhere. A lot of people don't know that knowledge and wisdom is like a relationship. What you see at first is really not what it is. There is always more. I mean, look at the similitude of your body. Your body changes. Look at the similitude of daytime and nighttime. It changes. Even as you and I speak, the tone and volume of voice changes. That itself should tell you that the algorithm of reality is never the way that you think it is, especially when it comes to information. Just as much as the days seem to be moving faster and people are seeing more eclipses more and more often, whereby once upon a time eclipse never occurred that often. Maybe every 50, 100 years eclipse occurred, but now we're seeing eclipse every 2-3 months, or at least 4 times in a year, whether it be solar or lunar. Things shift, and oftentimes when they shift, it's not to your detriment, it's to your benefit. The more you run away from these things that shift, the more you yourself are going against nature's law. And the whole concept of submitting to the will of Allah has nothing to do with some man somewhere that you have to be a slave to. So letting you know that the ebbs and flow of nature will not submit to your personal feelings of how you view things. The higher cosmic powers which influence the reason why these people structured all these paperwork that we're reading, however far-fetched it might be to some people, are directly linked to the natural ebbs and flow of nature. These people are master masons. When they construct these documents, they're not stupid people. These are very intelligent people who comprehend nature's law and move harmoniously with it, and they use it against you. Yet here you are running away from nature's law, failing and refusing knowingly and willingly to evolve according to nature's law. And many people are suffering from it. And even worse, your posterity and your children will suffer for it. Why? Because you are strong-headed. Evolve. It's in your nature. Be harmonious. But if you're stuck in thinking it's theirs, then you will always forever run away from it. It's not theirs. It's foundational principles that if you begin to read it, and stop for a moment and think about it, you will see the solution clearly given to you. Because on a federal level, equity is homogenized with at law. The principles, doctrines, elements, and tests of equity and at law are one. And because of that, there's no way that a problem will be created without the solution being within the problem in and of itself. It's like a flower that withers once its season is over. As it withers, its seeds drop and endows itself within the soil so that it can blossom again the next season. That's how all these rules that a lot of people run away from are. People's minds are so affixed on problem that when they read these things, the only thing they see is problem, which is natural principles of rhythm. Whatever rhythm you are is what nature would always reflect back to you. Change your rhythm and you begin to see the solution within the problem in and of itself. Don't make reference to the rules. Use the verbiage and the principles. Evolve. Your solution is right in plain sight. It's in front of you. It's not as far removed as you think it is. Would it assist you to have some special book that costs a lot of amounts? Yeah, it will. But nature's law never excludes anything. Everybody gets it. So if everybody gets it, that means whenever the good stuff comes, everybody also gets it. Meaning you don't have to be the most privy to something. And you don't have to be the most financially stable to be able to get books that cost $30,000, $40,000 before you can know how to fix your problem. It's right in front of you. On request by a defendant in a criminal case, the prosecutor must, meaning now you can invoke interrogatories, discoveries, etc., etc. But you don't do motions, right? That's cool. You don't do motions. The prosecutor must provide reasonable notice to the general nature, meaning general law, if they were using special law in the first place, which they will do. Upon your demand, they now have no choice. They must now utilize general law. Must provide reasonable notice of the general nature of any such evidence that the prosecutor intends to offer at trial. This is where so most people are aware of discoveries. But you can also do something as to ask them what their intent is of how they're going to use those documents rather than saying, hey, present me this document. You can do more than that. You can ask them how they intend to use certain documents, and it's right here. So within your discovery, on request by a defendant or your interrogatories in a criminal case, the prosecutor must provide reasonable notice of the general nature of any such evidence that the prosecutor intends to offer at the trial. And they must do so before trial or during trial if the court, for good cause, excuse lack of pretrial notice. And this sets you up for a motion to eliminate. Rule 405, method of proving character. By reputation or opinion, aka a court opinion that found you guilty, or the supposition of what they think you are. So in this new case, you're saying I'm not the ens legis, yet someone has an opinion out there that says yes you are. I'm not a resident of so and so, yet all the information about how you engage in contracting your daily life says yes you are. Even if it's not on a court docket or disposition, they're looking at you and seeing that, oh, you're receiving mail here and there, aren't you? Yeah, that's you. You are that ens legis. That is the presumption. That presumption can be admissible. Opinions can be admissible if you do nothing about it. By reputation or opinion. Reputation, presumed criminal history. When evidence of a person's character or character traits is admissible, meaning they've qualified with some of the factors that we've spoken of in the past. So when the qualifying factors are in place, it may be proved to testimony about the person's reputation. They're not saying artificial or natural. They're just using this blanket term, meaning presumption, until you prove otherwise. Merely saying you're a standing or capacity of one thing or the other is irrelevant. It has no standing in and of itself. It's meritless. When evidence of a person's character or character trait is admissible, it may be proved by testimony about the person's reputation or by testimony in the form of an opinion. Meaning the witness doesn't always have to be someone creating an affidavit or someone taking a witness stand. It can be other documents. But they can bring in and say, look, there's a witness. A piece of paper can be a witness. Because there's a general blanket term that there's a good possibility that this whole thing is fictional in the first place. But if you're saying that you're a man in the land, flesh and blood, and they have no jurisdiction, if you're saying you're a sovereign, if you're saying you're a secure party, if you're saying you're a creditor, if you're saying you're a more, then you are held against a higher standard as a natural man or woman. So you got to do better than merely sending a piece of paper in. On cross-examination of the character's witness, due process, the court may allow an inquiry into relevant specific instance of the person's conduct, due process. By specific instance of conduct, when a person's character or character traits is an essential element of a charge. Elements, remember I was speaking about elements? Whatever they're bringing against you, you have to know the elements, which are the qualifying factors to it, and the tests, which specify the instance itself as it relates to the elements and the supposition of crime that's been brought against you, or if you're the claimant, how you can make it work. Understand and comprehend the elements. Claim or defense. The character or trait may also be proved by a relevant specific instance of the person's conduct. They left it right there so vague that if you don't know the elements involved in your claim or the charges being brought against you, you're fucked, is what they're telling you. We'll leave it at that so that we don't take up too much time. Evidence is the backbone of everything. To be able to free yourself is to be able to know what qualifies as evidence and the different aspects of evidence and how it applies to the commandments that they are bound by. Take care and best of luck.
Hey, and also don't forget to join my Patreon if you haven't. There I go through documents that I have used personally successfully and videos that I do not post here on YouTube that are in many ways private in nature. And also I go through live audio interactions and video interaction of my own experience with certain things. And I also have a website where you can go through a list of documents or services if you need them. And these videos that are posted on YouTube are also uploaded on Anchor. You can listen to it via audio means. And there's an Instagram page and a Facebook page. The link is on the screen and in the description. Take care and best of luck.